Major breaking news. We had a huge oral argument in front of the entire United States Court of Appeals for the Third Circuit out of Delaware, New Jersey, and Pennsylvania involving 18 U.S.C. 922 G1, the so-called felon in possession statute. Specifically, the court heard en banc whether or not nonviolent felons can be disarmed for the rest of their lives, permanently, if you will, and whether or not a prior decision by the Third Circuit is impacted and requires it to be altered by virtue of the United States Supreme Court's decision in June of 2022. Let's break down this major oral argument between the anti-gun forces and the Second Amendment team when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon if you don't have a copy. And if you have a copy and have read it, feel free to leave a review on the book on Amazon. Okay, folks, major breaking news. The United States Court of Appeals for the Third Circuit out of the states of Delaware, New Jersey, and Pennsylvania have reheard the Bryan Range versus Merrick Garland ATF DOJ case, presenting the Second Amendment question of, under federal gun control statute, 18 U.S.C. 922 G1, the so-called felon in possession statute, that provides that if you have been convicted of a quote-unquote felony, then you can be disarmed for the rest of your life. And as we've talked about before, the federal definition of felony for the purposes of 922 G1 is not what you and I think it is. It's much worse. Specifically, if you've been convicted of a misdemeanor in state law in a state court where you potentially could have gone to prison for more than a couple years, even if you've never spent a day in prison in your life, that still constitutes a felony under 922 G1. And as of this moment in time, historically, even if you've never done anything violent or dangerous in any respect, you can still be disarmed for the rest of your life. And that is the issue presented by the Bryan Range lawsuit under the Second Amendment to this federal gun control law. Specifically, Bryan Range was convicted decades ago of a so-called welfare-related offense where he and his wife, or something like that along those lines, the specifics don't matter that much, but he applied for some form of state welfare, I believe from the Commonwealth of Pennsylvania, and he received it. But in applying for this welfare money from the government, he failed to disclose some lawn mowing, landscaping related income, and the state went after him, and he pled guilty to a misdemeanor charge. There is no allegation of any kind of violence in his past, in any respect. No evidence that he's a danger to society, danger in any way physically or otherwise to anybody or himself. Nevertheless, because he pled guilty to the state law misdemeanor and he could have theoretically gone to prison for multiple years, even though I don't think he went to prison for a day, under the federal statute 18 U.S.C. 922 G1, he technically qualified as committing a felony that disarmed him for the rest of his life. So he sued under the Second Amendment, claiming there is no way, based on the text of the Second Amendment and the historical tradition of regulation, dealing with restricting guns perhaps from violently dangerous people, this applied to him. And you may recall a couple years ago, he actually won this case before the United States Court of Appeals for the Third Circuit en banc that said, indeed, under the Second Amendment, the view of Amy Coney Barrett, then a judge on the Seventh Circuit, in the case of Cantor versus Barr, where she came out in the dissent that said, if you're not a violent danger to yourself or others, you cannot be disarmed permanently under the Second Amendment. That was a major decision by Judge Amy Coney Barrett, and I believe that was major in the sense that that is a huge reason why she was elevated to the United States Supreme Court, because that was a gap in her resume, support for the Second Amendment back in the day. I'm not going to get into the details, but I can assure you that was a consideration and concern. But she resolved that by virtue of her favorable Second Amendment ruling in Cantor versus Barr, which ultimately gave rise to her nomination and confirmation to the United States Supreme Court, where she sided with the Second Amendment in, for example, NYSERPA versus Bruin. Now, you may recall, Bryan Range won his case before the Third Circuit. The federal government, Merrick Garland, sought cert from the United States Supreme Court. The Rahimi case was then pushed ahead of the Range case. You may recall that the Range case and the Rahimi case were neck and neck in terms of what would go to the Supreme Court next, and the Range case was decided slightly after the Rahimi decision, and Merrick Garland, being a smart lawyer, even though he's an anti-American lawyer in my opinion, and not good on the Constitution, Merrick Garland was smart enough as a strategic matter to push the Rahimi case with terrible facts and terrible allegations about Mr. Rahimi ahead of the Range case. And the Supreme Court took the case that came to them first, the Rahimi case, over the Range case, which is unfortunate, but that's the way it is. I don't think it's a big deal at the end of the day, but it would have been nice to have Range in the Supreme Court instead of Rahimi, because Range is a much better fact pattern with a much better party than Mr. Rahimi was. Okay, with that said, the past is the past, and the Supreme Court granted cert to Rahimi, decided it, and in light of that, they decided to grant cert, vacate the decision of the en banc Third Circuit Court, and send it back to the Third Circuit for a re-argument, for them to reconsider whether or not the Rahimi case impacts the decision that the Third Circuit had previously issued. Now, there was oral argument this week in the Third Circuit, big fight, and I'm happy to report it looks like that the Second Amendment community is going to experience another big win here. Based on my review of the audio and listening to the argument at the time, it seems that all the tough questions were directed toward the government. And I'm going to, because I got the audio, I'm going to play for you the summary, the powerful summary of the Second Amendment attorney, who coincidentally is the same Pete Patterson that a day earlier had argued before the United States Supreme Court in the Vanderstock case dealing with the so-called ghost gun rule. And the very next day, he's in the United States Court of Appeals for the Third Circuit en banc, arguing in support of the Second Amendment on behalf of Brian Range. So I'm going to turn over, because I thought this is an excellent summary of the argument in favor of Brian Range, and you should hear it from the horse's mouth right here and right now. This is Pete Patterson on behalf of the Second Amendment and Brian Range in the Range case.
835. Counsel?
Morning, Your Honors. May it please the Court. Pete Patterson for the appellant Brian Range. I'd like to reserve 5 minutes of my time, if I could.
That'll be granted.
Thank you. Decision in Rahimi reinforces this Court's earlier decision finding Section 922G1 unconstitutional as applied to Range. First, Rahimi rejected the government's argument that as a matter of plain text, the Second Amendment is limited to responsible citizens. And for the same reasons, this Court should reject the government's argument that the Second Amendment is limited to law-abiding citizens. That term is equally as vague as responsible, and it was used in the same way in Heller and Bruin as was responsible. Second, Rahimi found a historical tradition of temporarily disarming those who threaten physical violence to others. Here, Range is being disarmed permanently, and the government admits he has never threatened physical violence to anyone. The government nevertheless argues that Rahimi supports its position, but the government is incorrect. One, the government says that it can disarm dangerous individuals. But of course, as we've argued, that principle has no application here since Range is not dangerous. So the government's argument boils down to the fact that it can disarm non-dangerous individuals who share a characteristic with other individuals the government contends are dangerous. But that cannot be right, and it would lead to startling results. Could the government disarm anyone under 30 or anyone living in a high-crime neighborhood? Surely not. And history does not support that proposition. The government, for founding-era evidence, cites primarily to laws disarming those who provided material support to the British during the American Revolution. But those are not valid analogs for several reasons. One, those individuals were viewed as having written themselves out of the people. Two, they were dangerous by supporting the enemy during wartime. Three, those restrictions typically were temporary, allowing people to swear an oath and get their rights back. And four, Bruin footnote 26 says that military measures are not valid analogs. And we can see that, or wartime measures, we can see that in a letter from General Washington cited by the government supporting these measures, where General Washington said, vigorous measures such as another time would appear extraordinary are now become absolutely necessary for preserving our country against the strides of tyranny making against us. The government second argues that it can disarm serious offenders, but serious suffers from many of the same vagueness concerns as law-abiding and responsible. It also is disconnected to the principles underlying the Second Amendment. Rahimi says the Second Amendment is consistent with common sense. And it makes common sense to say if someone threatens violence to another person, that person has forfeited their right to armed self-defense. But it does not make common sense to say that someone that's committed a serious crime, disconnected from violence, has somehow forfeited their Second Amendment rights. This also is not supported by history. The government points to the fact that some felonies at the founding were capital offenses. But that can't support the government here, again, for several reasons. First, this could have startling implications as well, as nothing in principle would separate the Second Amendment from any other right being stripped of a felon for life. And as this court held and explained in its prior opinion, the fact that some felons were subject to capital punishment at the founding says nothing about what their rights were, what the rights are of felons who serve their time and return to society as free individuals. And also, if this were a valid principle, the principle would be something like individuals subject or who commit an offense subject to capital punishment can have their rights taken away. But we would apply that principle to today's circumstances, and it would be individuals who commit capital offenses today. But this is all somewhat hypothetical because here Range's offense was a misdemeanor, and a misdemeanor has never been a capital offense at the founding or today. I welcome the court's questions.
Now, of course, the government had a lot to say. Now, mostly what the government focused on was trying to argue that the Rahimi decision watered down the Bruin principles, the Bruin methodology, and that's not true. Just to jog your memory, the Heller-Bruin methodology says you start with the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. Because this federal gun control law, 922G1, prevents Mr. Range from even possessing a firearm, it obviously implicates the right to keep, which means to possess, and the right to bear, which means to carry, because if you can't possess a gun, you can't keep or bear it. So obviously the text of the Second Amendment is implicated by virtue of this gun law applied to Mr. Range. So once the text is implicated, the burden shifts to the government. And what is the burden upon the government? The burden upon the government is, first of all, to identify a long set of historical analog laws going back to the time of the founding, put them all together, show that they're related, and derive some long-standing principle of firearm regulation from those multiple analogs. And that those multiple analogs and the principle derived therefrom must somehow be analogous to the modern-day gun control law. The how and the why, meaning the why those laws were enacted, and the how they were enforced, must line up with what's going on today. Now, all the laws that the anti-gunners, or I should say the federal government and the anti-gun movement, the Department of Justice argued and pointed out, were a set of laws, but none of them applied in my view, and I think the court will agree with this, because the only people asking tough questions were those asking tough questions of the government. Most of the tough questions were directed to the government, and there was really a trying to understand the Bruin-Heller methodology as applied through Rahimi. But in the end, as we've explained before, the Rahimi case is nothing more than an application of Heller and Bruin. It doesn't really expand or change the methodology. It simply applies that methodology. And most importantly, if anything, Rahimi actually improves the odds of Mr. Range winning, because the Rahimi case specifically said that none of the so-called dicta in prior decisions about responsible gun owners has any bearing whatsoever on the question of the Second Amendment, because Mr. Rahimi is part of the people, even if he has shown himself allegedly to be irresponsible, because that doesn't matter as a matter of text, and the Rahimi case cleared that up. So anyway, but nevertheless, it's worth hearing from Pete Patterson in his rebuttal when he stood up to address some of the arguments made by the government, none of which I think went very far. Let's listen to Mr. Patterson again as he explains why the government's case wasn't working at all in their argument in the Range case here.
Thank you, Your Honors. Just a few points on rebuttal. First, just as a methodological matter, what we view as the government's burden here is to, A, they need to identify analogs, identify the historical tradition that they rely on. Then they need to extract principles from that tradition, and then they need to apply the principles to say it's valid to, in this case, disarm Mr. Range. And they cannot do that here. And first of all, they've not found analogs that are applicable in this circumstance. They mentioned Livingston. Not only was that not applied, but that the punishment was that the person couldn't bear arms in the military. It did not even apply to personal arms. So that is wholly disconnected here. They've also talked about felony punishment, and they've said that the principle is serious crimes can be disarmed categorically, but that's just a sky-high level of generality, as I think we've seen, if that would result in people being indefinitely disarmed for things like jaywalking, or I think an example was given in the Felage dissent of an actual law removing a bottle of ketchup from the shelf, taking the cap off and putting it back on the shelf, I believe in New Jersey, that would subject someone to lifetime disarmament.
All right, folks, the bottom line is I feel optimistic that the Third Circuit Court of Appeals, with a decision, I think, maybe from Judge Bebas, maybe from Judge Hardiman, I think this is going to be assigned to a more senior judge on the Third Circuit Court of Appeals. I think it's going to come out in favor of the Second Amendment. I think the fact that Mr. Range was convicted of a misdemeanor with no evidence of danger or violence in his background at all is going to fall squarely in contrast, if you will. It will be dramatically contrasted to the Rahimi fact pattern that says that even if you're found to be a violent danger, you can be disarmed temporarily. Remember, Rahimi specifically said, even if you're found to be a violent danger to society, to others, which Mr. Rahimi was found to be because of him taking his girlfriend's head and hitting it against the dashboard, and when a witness allegedly saw it, he shot at the witness, and there was multiple other shootings involving Mr. Rahimi. So a lot of violence there. Even in the light of that, the Rahimi decision said that Mr. Rahimi could be temporarily disarmed, consistent with the Second Amendment, not even permanently. And here you have a non-violent offender who was convicted, A, of a misdemeanor, not a felony under state law, B, never spent a day in prison, and C, no evidence of violence today or at any point in the past, and nothing associated with danger in the past or today. So I think, Brian Range has a very strong case, and I think the Rahimi decision actually enhances the chances of Mr. Range winning. Of course, he had already won in the Third Circuit before. I think he's going to win again. And then, of course, I suspect Merrick Garland and the Department of Justice will seek cert in this case, which probably will not be heard until 2025, 2026. That will be the next term this is probably eligible for, just by virtue of the calendar. But anyway, that's my guess, and we'll see what happens. This is a very big case and a very good fact pattern, which is why Merrick Garland's probably not going to want to push the Range case to the front of the line for a 922G case. He's going to try to find some other bad pattern, but I'm not sure it's going to work out. And again, we don't know if Merrick Garland will be the head of the Department of Justice in a few months. It may be somebody much more favorable to the Second Amendment in just a few months, but only time will tell. We can only keep our fingers and toes crossed in the meantime. All right, folks, hope you learned something here today. Make sure you follow me at X at Fourboxes Diner. Please subscribe to this channel. We're trying to grow our numbers as best we can. We're very far behind, but we're working hard to catch up. And make sure you like this video, and we will see you again very soon, I hope, here at the Fourboxes Diner.
Orders up. Table 2A.